has been requested we save all questions till the end of the presentation because there's going to be a lot of information given out. So at the end, we'll open up the floor to you. If you could please mute yourself during the presentation so that we don't have background noise interfering with the presenters. And I would like to introduce everybody to Meghan O'Neill. She's a lawyer with Mills & Mills, and she specializes in estate planning and estate administrations. And Shawn Bausch from SB Advisors, Inc. He's a tax accountant, both a CP in Ontario and the US, and he does work in estates and trusts as well as other fields. Thank you all again, and I won't, without any further ado, Meghan, take the floor.
Great. Thanks for having me, Lori. I'm going to try to cover as much as I can in the next half an hour and then hand it over to Shawn. And we'll leave some time, about 10 minutes for questions at the end. Are you guys getting an echo from me? Because I am getting it. Which is not happening. So I think maybe, do other people maybe have to mute themselves? I'm not sure if that's what's happening. Yeah. Okay,
yeah,
so
I'll take care of it.
Can mute themselves?
Yeah, I'll take care of it if they don't.
Great. Okay, thanks, Lori. That could be incredibly distracting for all of you. So I just want to make sure that's not too annoying for everyone. So as you can see, it's Estate Planning 101 here. Estate planning is a pretty broad topic, so I'm going to cover what I can in this time. Just a general disclaimer, none of this is legal advice. Of course, happy to chat with anyone about their individual circumstances. The famous lawyer answer is it depends, but it is for a reason, because it really does depend on the circumstances how this would apply to you. But everything I'm talking about is just going to be general information. And so a general overview of what I'm going to cover, high level, is why you need an estate plan. We'll talk about probate tax planning, estate planning pitfalls to avoid, and some basics regarding trust. We won't get too deep into the weeds with trust because that could be a whole other presentation, but we'll touch on that topic briefly at the end there. So why you need an estate plan. You want control over appointing your executors and your attorneys. If you don't name executors, then your spouse or next of kin will need to apply to the court to be appointed the administrator in order to deal with your assets. And if you don't have a named attorney for property or attorney for personal care to act in the event that you're incapable of managing your assets, then someone needs to make an application to the court to be appointed your guardian to do that. And during this time where no one has the authority to act, no one has decision-making over how your assets are administered, and essentially they are frozen with no one having the ability to access those during that time, which can be extremely problematic. With a will, the executor at least has the authority to act from the will itself, even though third parties oftentimes won't release assets to the executor until probate is obtained. They'll still have the ability to deal with third parties and obtain the information they need to even do the probate application and apply to be the executor with the court. So it is really important to have a will for those purposes. Naming the beneficiaries of your estate and how you want things to be distributed. We'll talk about what happens if you don't do that. The terms on which beneficiaries receive their inheritances. If you don't have a will setting out, for example, trust terms for which the inheritance of a minor child or the inheritance of a disabled beneficiary are to be dealt with, then that can be extremely problematic. You can save administration costs by having a will and powers of attorney. It's always going to cost more not to have those documents in place on the administration side. To apply for probate without a will, it's going to cost more than applying for probate with a will, because there are some additional hoops to jump through, some additional paperwork to be done where we're applying without a will rather than with one. The cost of doing a guardianship application versus having powers of attorney in place in the event of your incapacity are also going to be far outweighed in the event that a guardianship application has to be done because those powers of attorney don't exist. And there's a lot of probate tax and income tax planning that can be done within the course of the estate planning. And without doing that at all, there's a lot of missed opportunities on both of those fronts. And avoiding litigation is another important one, where the intentions of the deceased are not known because there's no will. Then, or in the event of powers of attorney, who should be acting as guardian can lead to litigation as well. So just ensuring that the intentions of the deceased are accurately reflected and accounted for in the estate plan can avoid litigation, which again is always going to be much more costly, having to go to court for any purpose versus just spending the money and investing in having the plan done right in the first place. So if you die without a will, that's called basically dying intestate is the formal term for it. And the Succession Law Reform Act is a piece of legislation that will govern how your estate is distributed in that event. Oftentimes, what is set out in the Succession Law Reform Act will not reflect what the deceased's actual intentions are. And so with that, I've included on the next slide details exactly about how an estate gets distributed in the event that there is no will. So we do have the legislation to look at for this, but again, it's oftentimes not going to be completely in line with what someone would want to happen. The one important thing I'll note here is that there seems to be this common misunderstanding that if you don't have a will, then all of your money is going to go to the government. That is not the case. You basically have to die with no relatives in order for your estate and your assets to revert to going to the government. It's possible, but very remote. We do have this distribution scheme as set out on this slide. But commonly, so just to speak to one of the examples here, if you don't have a will, but you have a spouse and a child, then your spouse is going to be entitled to the first $350,000 of the estate, and the remainder is going to be split, one half to the spouse, one half to the child. Usually that does not reflect a lot of spouses' intentions. They actually want everything to go to their spouse on the first death. Or alternatively, in other situations, the spouse may not want they may not want $350,000 plus one half of the remainder of their estate to go to their spouse. For example, in a blended family situation, in those circumstances, oftentimes we have spouses, maybe it's a second marriage, each of them have kids from their own respective first marriages, and they want to provide more for their own kids within their estate plan rather than everything defaulting to the surviving spouse, who could then remarry and leave those assets to their next spouse. And so there's a lot of circumstances in which what is set out in the legislation is not going to reflect the intentions of the deceased, and therefore we want to make sure we have a will to set that out rather than having to default to this legislation, which is what I've set out in the next slide. Another thing that's not going to be covered if you don't have a will are those trusts that I briefly mentioned before that you would want to have in place for a minor child or a disabled beneficiary, or sometimes we refer to them as spendthrift trusts, where there's a beneficiary that is just not good at managing assets, and you want to make sure that they're not getting a huge lump sum of their inheritance outright, which they may potentially squander or use to their own disadvantage. And so we want to make sure that we have a will to account for that proper trust planning, which is not going to be accounted for if you have to default to what's set out in the legislation. There is an order priority if you can apply to be your executor in the event that you don't have a will. Again, that may not reflect your intentions, and so it's important that you have a will naming exactly who you would want to act in that event. You also have the ability in your will to name what we would call special trustees for specific purposes. So you may want one executor to deal with the majority of the executor's duties, say, but there may be particular assets, for example, a business, that you want someone in particular to be able to deal with that business because you know that they have the knowledge base and the experience to be better suited to handle the administration of that. Business succession is another, that can be a topic in itself as well, but something that you want to talk to your lawyer about. Depending on the nature of the business, sometimes the client is the business, and there needs to be a discussion of, okay, if something happens to you tomorrow, like who's going to answer the phone and what are the debts of the business that needs to be accounted for, which I'll talk about a little bit more as we proceed here. But also say you want control over who is administering your estate as well. So basically, to summarize this, if there isn't a will, we're applying for probate without a will, which again is going to incur more costs. And if there is a will, there's going to be a lack of access to those assets until probate is granted. Your spouse will not necessarily be entitled to your entire estate, depending on the value of your estate. One other important thing to note here is that a common law spouse does not inherit through intestacy rules. And also, just generally speaking, there seems to be an idea that basically being common law is the same as being married pretty much nowadays, right? There's this idea that a common law spouse has all of the same rights as a married spouse. And when it comes to estate planning, that is simply not the case. Common law spouses do not have the same rights as married spouses. So if you want to provide for a common law spouse, you really need to make sure that you have a will that specifically provides for them and names them as a beneficiary. And so that's extremely important where there's a common law relationship rather than married spouses. Minors would be entitled to their inheritance at age 18 without any trust planning set out in a will. And most people would agree that age 18 is way too young for beneficiaries, children, or otherwise to become entitled to a significant inheritance. So you need a will to be able to set out proper planning for any inheritance for minors. Or other beneficiaries in circumstances that I mentioned. Guardianship provisions need to be provided for those clients who have children under the age of 18. They want to be able to name a guardian. Granted, the guardianship provisions in the will are temporary for the first 90 days from date of death, but nonetheless, the court is going to give huge deference to what is in the will as to who the parents intended to be the guardian of those children, actually taking care of them, not during that temporary period, but then through court order, making that guardianship official is a very important piece of the estate plan for anyone with minor children. And then the intestate succession, again, dying without a will, has a lack of control over the beneficiaries, the executors, the trust planning that we mentioned. So all very important reasons to make sure that you have a will in place. Powers of attorney, these govern in the event that you're alive but you're incapable. It's your powers of attorney that govern who can make decisions on your behalf. We have a power of attorney for property and a power of attorney for personal care. So your attorney for property is the substitute decision maker that you name to make decisions on your behalf in the event of your incapacity. And they can really do anything on your behalf except make a will. So they are signing documents on your behalf, filing tax returns, paying taxes, and for attorney for personal care and the power of attorney for personal care, that person is the substitute decision maker that's going to have control over decisions regarding anything from nutrition, hygiene, refusal or consent to treatment. And because your attorney for personal care is the one making decisions regarding your care, but your attorney for property is the one who's actually managing your assets, they do need to work together to a certain extent, because the level of care that you are getting is going to depend on the level of care you can afford to a certain extent, and your attorney for property is going to be the one who's managing your assets. So who you name in those roles is really important, and if they're not the same people, how they can work together is an important consideration too, and a conversation that you're going to want to make sure you have with your estate planner to ensure that you've accounted for how they would be working together in their respective roles. These documents are just as important, and some would argue they're more important than the will, because if you don't have a will, there is that default in the legislation, despite all the limitations of it that I just mentioned. There is that default. There is no such default if you don't have an attorney for property or attorney for personal care named, whereby, again, someone's going to have to make an application to the court, which is going to be much more costly, and there's going to be this delay where no one has the authority to do these things on your behalf in the event of your incapacity. So these documents are very, very important to have in place, and it's important to do them while you're capable. Unfortunately, we see a lot of cases where it will be the adult children calling us and saying, my parents need a power of attorney now, but they're already incapable and they no longer have the capacity to actually give instructions for a power of attorney. So it's really important that these are done while someone's capable. Similarly to naming a special trustee in your will who can deal with, say, your business assets, for example, you can also make a limited power of attorney for business assets as well. If there's a person that you would want to deal with most of your assets, but you have someone in mind who's particularly better suited to deal with the business assets in particular, you can do a limited power of attorney for that purpose. So it's really important to have these in place as well. So I won't go over the takeaways, which are just a high-level reminder of what we went through in the interest of time. There are certain people that you have to provide for in your estate plan. And so it's important that you know who has the right to make a claim against your estate in the event that you haven't provided for them appropriately. And they are considered dependents. And dependents can be a spouse, parent, child, sibling, or anyone whom the deceased was providing support to or was under a legal obligation to provide support to immediately before their death. So it's really important that you know who these people are and have accounted for them appropriately in your estate plan to avoid a claim being made against your estate. So in these next slide, I go into detail about the definitions of who can be a spouse, who can be a child, which you can go back to in the slides. But it's important that you're having that conversation with your lawyer so that they can let you know what any potential claims might look like. And dependents are one class, and there's also creditors. And so if you're a business owner, you're going to want to take into account the debts of your business and who's going to have a claim against your estate for any such debts. And you want to make sure that you're appropriately accounting for that in your estate plan. So oftentimes business owners will use life insurance as a means of ensuring that there's liquidity in their estate to cover any debts of the company so that they're not in a situation where when they die, let's say the real property, and that can be the case, especially for a lot of people in Toronto or the GTA, their real estate can be a huge portion of their net worth. And if there's not enough liquid funds to cover their debts, or that of their business, there could be a situation where, say, real property needs to be sold in order to make sure that debts get paid. And so there's a lot of planning that needs to go into making sure that basically there's the asset breakdown in terms of liquidity available to actually cover those things, so that we're not in a situation where things that you would not otherwise want to have to be sold to cover that may have to be. In that case, oftentimes business owners have a policy that is owned by their corporation, and their corporation is also the beneficiary of that policy, and they are the life insured. Insolvent stages where basically the liabilities outweigh the assets, and that again could be a whole other presentation, but also say it's very messy. So making sure that that's appropriately accounted for in your estate plan is incredibly important. Claims by dependents or other creditors. Another creditor, for example, could be also an ex-spouse. And so we want to make sure that, again, if anyone had a claim against the estate, we're accounting for that. There could be claims of spouses or other shareholders based on a shareholder's agreement or marriage contract. If you have any of these types of documents, marriage contracts commonly known as a prenuptial agreement or prenup, you need to make sure that that is considered, and to give copies of those documents are given to your lawyers so that they can make sure that your will and the shareholder's agreement and the marriage contract all coincide and work as a team. You never want inconsistencies among these documents. You want them to be coherent and with each other. And so it's very important that your lawyer has the opportunity to review those contracts too, because they will inform your estate plan. And I've had cases where I look at a shareholder's agreement, and even though I'm an estate lawyer, I can see like one of the glaring oversights in it is that it doesn't deal with how are shares to be dealt with in the event of death or incapacity, in which case then our corporate team sometimes gets involved to review the shareholder's agreement, and sometimes updates need to be made to that because that's something that should be there. So that is all something that we'll be looking at in the course of reviewing the estate plan. I'll go over this one in the interest of time too, as I think I've covered that. And the takeaways here as well. You can go back to these slides as you need summarizing, but I'll keep moving along here as I'm getting short on time, I see. Probate tax planning, the one thing I want to say about this is that people get very sidetracked with probate tax, and they sometimes let it lead their entire estate plan, and it should not be the case, because sometimes that will come at the cost of other decisions with respect to the estate plan that really should outweigh the probate tax saving. So there's some simple ways that we can save probate tax, and we want to make sure we take advantage of those opportunities where we can, but we also don't want that to be guiding the entire estate plan at the risk of things that are more important. So essentially, the first $50,000 of the estate is exempt from probate tax, but everything over and above $50,000 is going to be subject to probate tax of 1.5%. And so probate essentially is the process of submitting the last will of the deceased to the court, them confirming that it is the last will, and with that, issuing a certificate of appointment is the formal name for it, but that's what we commonly refer to as probate. And that protects both the executor and third parties from liability acting under that will. So if probate has not been granted and an executor goes ahead and starts distributing assets, and then another will, a later will, comes out of the woodwork and it turns out that's the last will, then that person who distributed those assets is going to be personally liable. And any third parties who released assets, they're going to be liable. So third parties are not going to release assets without probate. And so that's essentially, practically speaking, why we need probate, what the purpose of it is. It's not going to be needed in every single estate. It's important to get legal advice, to look at the assets, look at the circumstances of the deceased, and see whether probate is needed. For example, on the death of the first spouse, probate can oftentimes be avoided because spouses usually own things jointly, and things will pass by right of survivorship from one spouse to the surviving spouse. But if one spouse owned assets in their name alone, probate may not be able to be avoided in that case. So all to say, upon death, someone needs to get, and specifically the surviving spouse, in that example that I provided, or whoever is named as executor in the will, needs to make sure they're getting legal advice to confirm whether probate is needed in those circumstances. An estate information return has to be filed after probate is issued. I won't go into too much detail on that one either in the interest of time, but I will speak to multiple wills and joint ownership. Multiple wills are a really important planning mechanism for business owners in particular. Seem to rely on these the most, although there are other types of assets that can be dealt with in a secondary will. But essentially in Ontario, we are allowed to siphon off certain assets, including shares in a private company, into a secondary will, and with that save probate tax on the value of the shares of that private company, assuming there's no shareholder that demands that probate be obtained for those shares. Then we can save the probate tax on the value of those by basically siphoning them off into the secondary estate, which is governed by the secondary will. So a lot of business owners will have two wills for this reason: the primary will that has to be probated, the secondary will that does not need to be probated and covers assets that will not be subject to probate tax. So we formally, their primary and secondary wills, sometimes people will refer to them as a personal and corporate will. They're the same thing, but it is a very, very common tool used and important tool to a strategy, if you will, to employ where there are private company shares. It's an easy way to save probate tax on the value of those private company shares. So it's important business owners explore having multiple wills with their estate planner. One thing I'll note about joint ownership, with spouses, there's an automatic right of survivorship, and where there's not a case where things are owned jointly between spouses, there's not going to be that same automatic survivorship. So where spouses own joint accounts jointly, investment accounts jointly, real estate jointly, when one spouse passes, that asset is going to pass by right of survivorship automatically to the surviving spouse. A common question that I get is, well, why can't I just name my kid as the joint owner once their children are old enough? They say, I'm just going to put my kids on title, and that way it's just going to pass to them and it'll avoid probate tax. It is not that easy. The right of survivorship default does not apply automatically where the joint owner is not a spouse and rather is an adult child. And that comes with a number of potential risks, drawbacks. One being now that asset that the adult child has now been added as a joint owner to is now exposed to the creditors of that child, if any. And even if they don't have any now, that child, they could down the road if they were to get into some type of accident where they're now being sued. Now the asset for which they are joint owner on, that is really your asset, but you just named them on for probate tax savings, is now going to be exposed to the creditor claims of that child. When we're dealing with real property, we can lose part of the principal residence exemption if that child is not also using that residence as their primary residence and they're in fact living with their spouse in their own home. So there are tax consequences that can result from that too. There's loss of control. Now the child is going to have to be signing off on every transaction regarding that property. And that is not always the intention of the parent in that regard. So that's another reason we don't want to just go ahead and be adding adult children on title. There are ways that we can have further discussions about this type of planning, but it really only works in very limited circumstances, and you have to make sure that you get legal advice so that everything can be very properly documented. There's also, if you were to do this without the proper legal mechanisms in place to have the plan actually reflect your intentions, the default is not going to be that probate tax is saved in any event, because there is a presumption of what's called a resulting trust, meaning if you just do nothing else and you just add an adult child on title to property, the presumption is going to be that they're holding it in trust for the benefit of your estate, meaning you're not going to save probate tax automatically. So there has to be far more planning done to account for that potential circumstance. But again, most of the time, except in very limited circumstances, and even then, it has to be very carefully documented. That is not going to be the recommendation to be adding an adult child as a joint owner. And a lot of times that's considered a easy estate planning tool, and it's really much more complicated than that. I'm going to spend just a few minutes on beneficiary designation, or hopefully even shorter, because I know we're running short here. Beneficiary designations, essentially if a beneficiary survives you, whether it's on life insurance, an RSP or RIF, TFSA, segregated funds, that asset is going to pass outside of the estate to the named beneficiary. It's not going to be subject to probate tax, and it's not going to be caught up in that probate process, meaning there's going to be sooner access to the beneficiary to that policy or plan, as the case may be, because it doesn't have to go through probate, which is through the court. As I mentioned, the probate process and getting probate from the court can easily take 6 to 8 months, whereas if you have a named beneficiary on a life insurance policy, for example, the life insurance company is going to pay those proceeds directly to that named beneficiary outside of the estate. So it's a faster payout. It's also not subject to that 1.5% probate tax. How you achieve the beneficiary designation is important to discuss with your estate planner, because there's different ways to go about it. One would be doing the designations in the will. There's also forms that these companies provide, but the forms are limited in what they can provide. For example, an out of order death where a child predeceases a parent. You can only name, let's say you have a spouse and then your children named as the contingent beneficiaries. If one child predeceased, their share would just, essentially everything would just go to the surviving child, rather than there being gift overs for the share of a predeceased child, which is the intention of most people, to have gift overs and further trust planning, which can't be accomplished on those forms. So it's important. How the beneficiary designation is going to be achieved is an entire discussion that needs to happen with the estate planner. Joint partner, alter ego trust, those again could be an entire presentation, but essentially those are available to people who are 55 years and older. And those may be a good alternative for certain clients, not everyone. There's some drawbacks to those. Some being that they are a little bit more complex, and not everyone is interested in that level of complexity for their estate plan. For most people, the main objective of that is probate tax savings. There's not going to be income tax savings achieved through a joint partner trust or alter ego trust. So for most people, it is probate tax, but there's a lot of other factors that need to be weighed against the probate tax savings, including increased trust reporting requirements. If real property is owned by a trust now, there's even additional reporting requirements under what's called the Underused Housing Tax Act now. So all to say, that's not the right fit for everyone, but those trusts are out there and could make sense and may make sense in certain circumstances. But again, a conversation that needs to be had based on your circumstances. Other benefits to keeping assets outside of the estate is just privacy, the savings of an executor, compensation, legal fees, and protection from creditors in certain cases. So I've already mentioned some of these things to be aware of, not letting probate tax plan guide or planning guide or savings rather guide the entire plan. Income tax, capital gains are going to be a far more important consideration as opposed to that 1.5% probate tax. So I am going, and I think that's actually a good handoff for me to hand off to Shawn, given, as I just said, the tax consequences are really far more consequential than the probate tax. So there's some more that's covered in my slides there, and they're pretty detailed. There's only a few at the end that I didn't get through there. So I'll leave it to everyone to review those slides if they want to see what's left there. But most of what I wanted to cover here and the big topics that I have, and so I'll hand it off to Shawn now.
Thanks very much, Megan. Okay. Let's see if I can do the technical switch. Can you see my first slide? All right, excellent. So, thanks again. As you can probably see already, estate planning is a very complex area of tax planning, and it's a challenge to cover all of the meaningful considerations within the time allotted for this meeting. This was planned as a series of seminars with successively more detailed information in each seminar. So the purpose here is to give you some highlights and raise some issues which might, generate questions in your own minds, about what might happen, on your own passing or the passing of family. So we welcome any of your questions which you might like to pose after the presentation, so that we can get into more detail specific to your situation. So, again, all of the information that Meghan has covered is something that we are holding top of mind when we are developing a tax plan for our clients. We work very closely with lawyers in estate planning matters because they have the overview of the legal landscape beyond just tax or even just income tax. Well, we can bring the administration planning piece to the picture. So we're going to look a little bit at how the financial figures are reported in Canada's tax system on the death of a taxpayer and the effects to the taxpayer. Because in Canada, it's the Canada Revenue Agency that enforces the Tax Act in Canada. So when you're reporting your income taxes on death, you want to ensure that they're going to be judged by CRA in the manner that you intend. Okay. So we've got two items here I've touched on. We've got tax compliance considerations. What do you have to file on the death of somebody in Canada? And then you've got tax planning, which is about quantifying the potential tax liabilities on death and planning for the funding of those liabilities. Okay. So what needs to be filed? Meghan touched on the estate administration return, or EAT return, formally or commonly known as probate. So that's due 180 days following the year end. And, often it's a lawyer who files that return. It is sometimes the accountant who files that return. And that's where all of the property owned by the decedent is going to be reported. Now, there's some information that's going to be on that return, which could be important for other filings that have to be made, and that is the fair market value of assets, because you're going to want to make sure there's consistency between the fair market values reported on the probate return and the fair market values that are going to be reported on any other returns that have to be filed. So other returns that need to be filed. So just as while we're alive, there is a personal tax return that has to be filed for a decedent, a final personal tax return. And coming with that, there are opportunities. There are some significant planning opportunities as a result of that obligation. And it has to do with the manner in which the items of income are reported and the manner in which any special items are reported. For example, for the last surviving spouse, on the passing of the last surviving spouse, the deemed disposition of assets. And I'll touch on that in the next slide. What other returns might need to be filed? You could have down the road, there could be, if the estate is still in existence, it hasn't been wound up within the first year, then you're going to have a trust tax return to be filed. And it'll have special characteristics to it depending on how long or how much time has passed since the person died. Other returns, there could be other returns in addition to those as well. And I'll touch on those in just a moment. Okay, so personal tax returns and the obligations around personal tax returns. So very high level, if a person dies in November or December of any given year, the tax return, the final personal tax return, is due 6 months after death. If the person dies at any other time during the year, then the personal tax return is due by April 30th, just like any normal tax return. And what has to be on that return? Well, all of the income earned by the individual up to the time of death, just as would be if they were alive, has to go on that return. Now, in addition to that, in special cases when it was the last surviving spouse who's passed away, there is going to be, and Meghan's touched on this already, there is going to be, generally speaking, a deemed disposition of their assets, which means their assets are going to be deemed to have been sold at their fair market value, and any resulting gain between the cost of those assets and their deemed fair market value is taxable on that return. And this is, again, as Meghan has said, this is one of the most, or potentially the most, significant tax liability arising as a result of the death of a taxpayer. Because, for most people, you're accumulating assets over the course of your lives. And especially in the case of, for example, of business owners who started a corporation by buying shares for only $100 and grown that corporation over, a decade or two or three, obviously there can be a huge gain. And planning for that liability is of paramount importance. A little bit about the opportunities. Again, this is high level. It's trying to give you a sense of what's possible, to raise some questions in your mind. Rollovers, as Meghan mentioned, when it's the first of two spouses to pass away, the surviving spouse can receive much of, or potentially in some cases all of the property of the decedent at cost, which we call a rollover, and no tax would be triggered. But there are considerations in this regard. For example, RRSPs. It's not quite so simple, and I'll get into that with an example in just a second. Tax planning. What kinds of tax planning can be done? Well, believe it or not, there is the opportunity to take advantage, perhaps, of twice the amount of usual exemptions required. And depending on how we structure the reporting of the returns that can be filed on the death of a taxpayer, you might get 2 exemptions. If you're in particularly good circumstances, maybe 3. Also, other exemptions, capital gains exemptions. It's a really big opportunity for planning there, especially if we're talking about the shares of a private corporation. Okay. The trust or estate tax return. So an estate tax return has to be filed by 3 months following its year end if it's a graduated rate estate. For the first 3 years following the death of a taxpayer, the trust or estate return can be filed as a graduated rate estate return. And in that case, you'd be looking at something geared, keying off of the date of death, and that return is going to be due 3 months following the year end. After that period, when it's longer than 3 years after death, you're going to be in a normal cycle, and the estate is going to then default to a calendar year end, and those returns will then be due by March 31st. What has to be reported on those returns? Well, just like an individual, all of the income earned by the estate, so if the estate is sitting with capital assets, investments, still earning income of any kind, the income is going to be reported on that return, and it's going to be taxed on that return, unless there's planning done. And what else has to be reported? Well, any distributions by the estate need to be reported. And I think, as Meghan has mentioned already, what's key here for estate taxation is that the executors ensure that all of the income tax liabilities of the estate are satisfied, because the executor is personally liable for any income taxes of the estate that have not been properly paid. Okay. Any other returns? I'm just going to mention them here, and I'll commend these to your reading following the presentation. But these encompass some of the opportunities that are available for planning. Okay. Rights of things return as a personal return. If there are shares of corporations in the estate, obviously the corporations still need to file their annual corporate tax returns. Likewise, any partnerships in the estate, similarly, if there are any other returns connected with the property of the estate, for example, if there's an underused housing tax return required, those still need to continue to be filed after death. Okay, if circumstances require. Okay, how much will you owe? Right? What is subject to tax? We've spoken about rollovers. RSPs are potentially subject to tax if the proper planning is not affected. U.S. situs assets. I'll just mention this here briefly because I am a U.S. accountant as well as an Ontario accountant. If you have assets in the United States and you die owning those assets, there could be a U.S. tax liability, and even if there's not a liability, there could be a reporting obligation. So if you do have U.S. situs assets, for example, a vacation home in the United States, or maybe you own shares of a United States corporation, it's important that you get some specific advice on how those will be handled on your death or the death of your spouse. Okay, how much tax will you owe? Right. All right. Generally speaking, it's taxed on the final personal return at regular rates, right? Just as if you were filing a regular return. If you're in the situation where it's the last surviving spouse and there is a deemed disposition, that's a capital gain. Highest rate is 27%, just under 27%. Really key here to watch out for potential double taxation on this return. I'm going to talk about that on the next slide, briefly touch on that. How to fund the liability? Well, generally, we're looking at liquid capital in the estate, whether that's securities that can be liquidated if necessary, life insurance that was planned for in advance. And this is where your tax planner comes, their expertise comes into play, and other strategies as well. Okay. Very quickly, an example to give you an illustration of a very common problem for owners of private corporations. I think that could be a lot of people in this meeting. So as I mentioned before, for example, maybe you started a corporation, you bought years ago, you bought some shares for $100. Maybe you've grown that over the years and now it's worth, let's say, $5 million. Well, if you're the last of you and your spouse to die, or whoever's owning it, the taxation on the final personal tax return, there's going to be a deemed gain on those shares. And the deemed gain is going to be the difference between the fair market value and the cost base, just effectively $5 million. The tax on the personal tax return, is going to be $1.3 million. Okay. Then the taxation on the extraction of the assets. Let's say this company it's got assets in it. Let's say it's either liquid assets, a portfolio, or a combination of, maybe even worse if it's real estate, because then you have to sell the real estate to raise the money to pay the tax bill. When those assets come out, or the cash resulting from the sale of those assets come out of the corporation as a dividend to whoever is holding the shares after the death of the taxpayer, there's going to be another tax bill, because that's going to be a dividend reportable on their personal tax returns. And this is the top dividend tax rate at the moment for ineligible dividends. There you see the total tax on that resulting disposition, almost 75%. Not desirable at all. Very important you get tax planning if you're owning the shares of private corporations. Another common problem, and I'm just going to leave this with you, this is my last slide, RSPs. They're supposed to be fully tax deferred, right? We put money in, we get a deduction, they grow over time, we're not taxed on them. Well, if it's not properly planned for at death, there is taxation. You've got the deemed income on the fair market value of death, which will go on the personal tax return of the decedent. And the top marginal rate for an Ontario resident right now, combined federal Ontario, is 53.53%. Tax on an RSP worth $185,000 is going to be $99,000. And then we've got the fair market value to the spouse. Let's say between the time of death and when it's distributed to the spouse, there's some appreciation. Well, that appreciation is going to be taxed in the hands of the spouse. So now you've paid 53% tax on something that was supposed to be fully tax deferred. So very important to plan for this so that it's properly deferred on death. Okay. And that's the end of the items that I'd like to raise for your consideration here.
Thank you very much, both Meghan and Shawn. If there are any questions, please, this is the time to unmute yourself and ask away.
No, I don't have any questions. Thank you.
Okay. That was very lots of information that was shared. So thank you very much. I will have both slide decks made available. If anybody would like a copy, please let me know. I can get that to you. I'll also ensure that the contact information for both Meghan and Shawn are included in an email following this. And ideally, everyone will get the email promptly, and there will not be any delays. Again, my apologies. My new email address, for some reason, stopped working at some point yesterday afternoon. My apologies for the delay in getting that link to you. It should have been there yesterday afternoon. If there's no further questions, I'm going to thank Meghan again from Mills & Mills and Shawn from SB Advisors for taking the time to come and join us today. This is the first of a 4-part series, and we look forward to the follow-up 3 presentations.
Thank you.
Thank you
very much. Thank you all. Thank you, Laurie.
Thank you.
Bye, Meghan.
Thank you. Bye-bye.
Bye.
Thank you.
Thank you.